Yeah. Akhuluma. Yeah. Akhuluma.
Good morning, colleagues. Good morning, colleagues. Is Mr. Voss here?
Yes, I am.
Yes, Mrs. Smith? Good to
I'm
go?
here.
Yes. Judge Van der Merwe, Judge Nichols, Judge Hughes, and Judge Mutajani. Good morning to all of you. Good morning, colleagues. You can call the matter, Lisa.
Thank you, Judge.
Good morning, colleagues. Mr. Voss here?
Number 846 of 2020.
Yes, Mrs.
Thank you,
Smith?
Judge.
I'm here.
Judge Van der Merwe, Judge Nichols, Judge Hughes, and Judge Mutajani. Good morning to all of you. Thank you. Good morning, colleagues. You can call the matter.
Thank you, Judge.
Respondent.
Good morning, colleagues.
Number 846.
Appeared. This was also sent.
I'm sorry to interrupt, SLD. We can't hear you.
Sorry, I can't hear you, Mr.
I'm
Smith.
sorry to interrupt. I'm sorry to interrupt, but you've broken up. We can't hear you.
Can you hear me now?
No, she's frozen. Yes, thank you, Justice Alito.
I would like to, on a point of abundance of caution, that on page 58 of the first and second respondents bundle, called Judgments Not Readily Available,
Yes.
you will see there is an order dated the 22nd of May that was presented by you, in which you will see Judge Nichols appeared.
Yes.
And it was CC'd to the Seri Law Clinic, and I thought I would just bring it to your attention that you both are aware of it, and it doesn't impact on the legal point before us, but I thought I would just bring it to both your attention before we proceed with the matter.
Thank you, Justice. I agree with you that it has no bearing on the matter before this court.
Mr. Smith?
we're an idiom on that, Justice Alderman.
Thank you very much. Mr. Foss, we've read the heads of argument. I see there's an application that you brought that the appellant be granted leave to argue that the third respondent's decision to convict the appellant at the disciplinary hearing was tainted by bias. Do you still persist with that application?
We do persist with the application, and
on what basis do you do that?
we have set out in our heads of argument, Justice, the grounds upon which we say that is a good reason or good ground of review. And what happened was that this point was argued before the court au quo.
Yes, and the court au quo dismissed that as having no prospect of success. When the court does that, that you are supposed to bring an application, a petition to the Supreme Court of Appeal on that point.
I think we do quote in our heads what we perceive to be the law, and we submit that whether we bring a petition or whether we apply to have this point allowed to be argued by this court.
But you haven't even asked for a condemnation. You haven't even asked for condemnation in your papers.
We didn't ask for condemnation because we submit that it's not necessary to ask for condemnation because we're bringing an application. We asked this court to consider that point, and if there's no merit in the point, then the application cannot succeed, clearly. But if there is any merit in the point, then the application should succeed. Whether one brings a petition or whether one brings an application of this kind makes absolute no difference to the substance of the matter itself. If it's a bad point, then the application should not be allowed, and that's
Mr. Foss, you brought an application for leave to appeal in front of the judge president, and on this point, he actually found that there was no prospects of success, and he actually gave relief on the point of the legal representation. Do you accept that?
Yes, I do.
Is there anything further that you would like to say?
No, there's nothing further I'd like to say.
Yes, Mr. Smith. You're on mute.
I apologize, Justice Alduka, I'm a Luddite. I'm still trying to arrange how to learn how to switch on my computer. But we associate ourselves with the finding in the court au quo that there's no merit in the point in any event, but it's not properly before you, and we believe that we should be focusing on the point on which, the ground on which leave to appeal was granted, and only on that.
Yes. Colleagues, do you have any further questions for Mr. Smuts? And Mr. Foss, do you have anything in reply?
No, Justice, I've made my point, and we also make the point in paragraph section D of our heads of argument that we submit that the formal petition is not necessary, but we accept that we have to ask leave to argue the point. That is how we presented the matter, and that's the only argument I have.
Yeah, you see that we can't just create precedents by allowing this. Even if we accept in some way that this is now a petition against the refusal of leave, we must ask for condemnation for the delay. If you don't even make a case, there are many cases where we refused condemnation, even accepting that there was good merit, because there's no proper explanation. The case that you referred to, those rules said a court can condone delay. So obviously you must give an explanation.
Justice, I can't take the matter any further. We did not ask for condemnation, and if we were supposed to do so, clearly we didn't do it. So I can't take the matter any further.
Yes, Mr. Smuts, are you still on the platform?
I was incognito, but I'm here, Justice Holden.
Yes, have you heard everything? Thanks very much. I think we will adjourn for about 10 minutes to give our decision on that application.
As a court, please.
Yes, we will adjourn for 10 minutes. Voss is there, Mr. Smuts, Judge van der Merwe, Judge Matajane, just waiting for Judge Nichols and Judge Hughes. Judge Nichols. Thanks. Judge van der Merwe, Judge Nichols, Judge Hughes, Judge Matajane, Mr. Voss, Judge Smuts. Mr. Smuts is here. Yes, thank you. The appellant has brought an application, and having heard counsel, the application by the appellant for leave to argue a further point on appeal is dismissed with costs. Thank you. Mr. Voss, you would like to get on with the merits of this matter now?
Yes, thank you, Justice. May I start with going back to the judgment for leave to appeal by the Honourable Deputy Judge President, Mshlongulela. I want to refer the court to page 751 of the record of appeal, and that would be volume 5.
What page is that, Mr. Voss?
751 of
751. Yes.
It's paragraph 8, and the part I want to read starts at just above line 20, where the court defined the question as follows. The question of law arising in the matter is whether the right of the applicant to legal representation, as affirmed in the case of Umata and others, extends the meaning of such a right to include that the applicant was also entitled only to the services of one and the same chosen counsel, even if the absence of that counsel, albeit without sound reasons, meant stalling the disciplinary hearing. Now, with all due respect to the court au quo, we submit that that is not the correct phrasing of the question before this court. And we say so for the following reasons. First of all, we submit that there are different facts to each case, and each case and each question must be asked and answered in relation to those different facts. This is not a case where the appellant chose a certain counsel and now, in spite of the fact that they're not available on a certain date, refuses to change counsel or anything like that. That is not the question. She had counsel from the beginning. Over a period of several weeks, the matter unfolded before Mr. Hutchinson, the third respondent. The matter was postponed.
Mr. Voss, if I can come in here. It seems to me that what you read here on paragraph 18 is just part of the reasoning. That isn't itself the leave granted. What was the leave granted is to be found in paragraph 50, which states that the grounds of appeal enumerated there has merit. Driven to conclusion that the prospect of success exists.
Yes. Yes, so that is
What you read on 18 is just his reasoning. That
Right.
itself doesn't relate to any outcome of the appeal.
that may be so.
That's the reason why he grant you leave on the grounds put out in paragraph 50.
Yes, Justice, I accept that, but I just wanted to use this as a starting point for my argument, that what we're dealing with here is not a simple matter of a chosen legal representation. We are dealing with something slightly different, and that's the only reason why I wanted to start there. And I understand that that's not...
The context is all important.
Yes. So what I wanted to say in relation to what the court said in the that one must start from a position where the issue is that a person is entitled to legal representation. Definitely of their own choice, obviously. But that must be circumscribed, and obvious there are circumstances where one can't insist on the same counsel. The question is whether this particular case is such a case. Now, we submit that there is no cogent reason given by the university why the matter could not proceed on the 29th of November. The university, on behalf of the university, Mr. Milo said that the university wants the matter to be finalized before the 20th of October. That was his argument in court when they discussed the dates. The fact of the matter is that the matter was in any event postponed to a date later than the 20th of October. So it was this, I think, 26, 27 October, and then again 6, 7, and 8 of November. That's the...
Now, the postponement, Mr. Frost, was done at the time when the proctor was well aware that the counsel for Ms. Dyantyi was not available.
Exactly.
And he was also aware, well, she was writing exams in November, but what I'm trying to say is that when you read the transcript of the 11th of October, there appears to be some discussion about these dates. But the one thing that comes out, I mean, for me, when I read the transcript, was that you were not available. And this is a apartheid matter.
Yeah, I'm just for the record, I'm not the Mr. Foss that's being referred to. There's another Mr. Foss.
Yes, but Mr. Foss was not available on the 26th, the 27th, and the 6th. The availability for Dyantyi's counsel was the end of November. Was there any particular reason for the university to have this completed by, let's say, the 20th of October, which was one of the dates that was mooted, or the end of October?
What Mr. Hutchinson says in his in the discussion, and that is perhaps important, when they were discussing the dates, he said the university wants this matter to be finalized, even if it means postponing it to a date where counsel is not available. He's not, Mr. Milo said, it's not something he really wants to do, but it can't be helped because the university wants the matter to be finalized. No particular reason has been given for why it must be finalized by the 20th of October. Well, firstly. Secondly, as I've already indicated, the matter was postponed to a date later than the 20th of October. Why? Because the other people were not available for earlier dates. Mr. Fungilia, I think, wasn't available, and the proctor wasn't available, or whatever. So, why wasn't the matter, if it was so urgent, why wasn't the matter heard earlier in October? There is no indication on the record that that was discussed. What was discussed is the university will be available on the 26th and 27th. The proctor is available on the 26th and 27th, and the other counsel for the other person that was prosecuted in terms of the disciplinary code was available. The two counsel acting on behalf of Ms. Dyantyi was not available. And there was First of all, at the hearing of the 11th, nobody said that counsel was not telling the truth when she said both counsel is not available due to previous commitments that they couldn't get out of. So that is not the issue. So we have to accept that their version is correct. And we can see that also if one looks at the application that was brought on the 20th of October before Mr. Hutchinson, the formal application for a postponement. In that application, first of all, was not formally answered by the university. So the allegations made in that affidavit must be accepted as correct. There's no indication that they weren't available or could make themselves available in any way or form. So the court must accept they were not available, and in spite of that, the matter was postponed to those days. The question is then whether it can be regarded as procedurally fair under the circumstances. Now, the first problem that we have is that Mr. Hutchinson, the third respondent, does not give any reasons. He didn't give a reason in the court when he gave the ruling on the 11th, and on the 24th, when he made the ruling to refuse the application, he also didn't give any reasons as to why. So he didn't say, you can get someone else in your place, you can use your attorney to deal with the matter. None of that was said by him, so he didn't give, we don't know why he refused the application, except perhaps that the university asked him to postpone the matter to those days, and he simply accepted that.
Now this, on the 11th of October, it was postponed to the 26th of October. Now Mr. Voss was appearing pro bono.
That's correct.
And there were then 14 days for whoever was going to represent Ms. Dyantyi to prepare, because this was a very crucial time of the inquiry.
Exactly.
Because he was going to be leading the evidence. Now, what about the remainder of her legal team?
Well,
Did they have a sister?
Yeah, there were two counsel, two advocates appearing on behalf of Ms. Dyantyi, and they were both not available due to previous commitments. The attorney of record, we only find that out later on, was about to go on paternity leave, and
but is it fair to say you've been represented in a long acrimonious matter by two counsel, now suddenly your attorney must carry it?
No, absolutely not.
Next time.
No, that is absolutely my point. There is no fairness whatsoever. Nobody.
Whether they had a baby or not, or whatever, doesn't matter.
Yes. No, I agree, Justice van der Merwe, that the question is simply whether one could expect someone else to stand in for counsel under these circumstances. We know that the records. Yes.
Can I just pose a question? Why was the suggestion that this hearing continue over the weekend or for particularly long hours? Why was that rejected out of hand? I mean, tribunals, as a matter of course, often run over weekends and have longer hours. They're not restricted to court hours.
That is correct, Justice, but that's not the reason. I mean, the matter wasn't postponed to a weekend. If that happened, then they would have had to make themselves available for that weekend. That is for sure. The discussion was around the weekend, and they said that the people from Syria doesn't work over weekends, or can't work over the weekends. That was the instruction she had, and nobody pursued that. I mean, it's not as if the court decided I'm going to postpone it to a date where they are available over a weekend. So the weekend issue is, in my submission, is something of a red herring, actually. Because that is not the point. The point is he did not postpone it to a weekend. He did postpone it to a date he knew that they were not available. So the question simply is this: whether under these circumstances one could expect her to find other counsel that could steep themselves as deeply into the matter as those two counsel were after several weeks of hearing and 700 pages of record. Now, something that is very important that I want this court to take into account is that we're not talking about any normal kind of case. This is where counsel acting pro bono. They are doing it for free. All the time they spend, all the effort they put in, they're doing it without getting paid. And I submit that this court can take judicial notice of the fact that it's very difficult to get counsel to do that, to work for free under these circumstances. So where were they supposed to find different counsel that could, within a short space of time, become completely au fait with this matter? I mean, I can't see how anybody could expect that of them, and especially given the fact that we're dealing with a pro bono case. So under these circumstances, if one takes into account the facts of the matter, it is very difficult to understand why Mr. Hutchinson refused the application to the 29th. Now, one would understand if there was a counter proposal. I mean,
he may have sort of shown his hand when he said, to recall on page 131, page 131, paragraph 189, where he said that Ms. Dyantyi had no intention from the start to testify in her own defense.
Yeah, but that is completely unfair, because
on what could that have been based?
Nobody knows, because during the hearing, they even asked the right to have her excused from sitting in the hearing so that they can prepare her evidence prepare her so that they could lead her evidence. So
so you have a position where the third respondent gave no reasons whatsoever except saying this.
Yeah.
Which is completely unfounded.
Exactly. So based on that, it's so difficult to argue a matter where the point that one is trying to make is so simple. I mean, it's either fair or it's not. And
you get better by repeating it. So.
Yeah, so that's why I'm not going to repeat it. I just want to say that I will deal with the issue of costs after Mr. Smuts has addressed the court. But we do make the point in our heads that the buyer watch principle is applicable under these circumstances. But maybe I will address the court on that point after Mr. Smuts has had his opportunity.
Yes, thank you. Mr. Smuts?
I have found the unmute button, Justice Alderwood. Thank you.
We all had to get used to this.
I'm still not used to it, I'm afraid. I'm sorry.
Some to a lesser extent, me included.
The issues have been limited now to the issue which was really raised halfway through the unfortunate series of events which manifested the application for leave to appeal when George Mhlangulelo DJP raised this issue about retention of specific legal representatives. And we start off by saying that in the application for leave to appeal and in the notice, there is a blurring of the concept of legal representation because the complaint is phrased as if there was a refusal of legal representation and a refusal to indulge the counsel, who, though they were acting pro bono, were held themselves to be unavailable on weekends when staff were unavailable. Why staff were relevant, we don't know. There's no indication that any staff were to be called as witnesses. And of course, there's the very real issue that part of the unavailability in the period running up to the postponement date was attributable to the fact that there was an attractive conference in New York to which counsel wished to go. Now, there are unfortunate clashes in one's professional commitments, but that aspect, that for a period in which the matter could otherwise have been heard, it could not proceed because the two counsel involved were heading for New York, receives no attention in the context which was discussed by Justice van der Merwe and our learned friend. It's ignored. They were going to a conference, and so the matter couldn't proceed. And it is important, if we're dealing with context, that we focus on the fact that the dates which were envisaged had been discussed previously. They were dates when the attorney and the other accused in the disciplinary proceedings were available. They had held themselves available. The proctor had held himself available. And with respect, it wasn't something that...
Mr. Smith, I'm sorry to interrupt you, but on that point, where exactly, I tried to find in the record, where exactly or were these dates discussed previously?
There seems, I can't refer you, Justice Nichols, to the specific point. It appears there was a great deal of off-the-record discussion, debate from time to time about these dates. It's not disputed that such discussions were held, and both the proctor and Mr. Powers, who represented one of the other accused, placed on record that these dates had been discussed, that they were available, that they had held themselves available.
Where is that reference, at least, where you said Mr. Powers said that he conceded, or he said that those dates had been discussed?
At volume 4, page 668, line 6, Mr. Powers says the following. Chair, it's now been several weeks since I proposed to Mr. Meadow the dates of Ms. McFall's and my availability of 26th and 27th October. So we've held ourselves available in respect of those dates for an extended period of time, and I've indicated again today that our availability is there. And part of the reason for those dates was, and Ms. McFall has what is colloquially known as SWAT week. As I understand it, that's when students try and study in the space of a week everything they should have been studying for the previous year. In other words, learning for exams. And so those dates tie in with that and my availability. On the other dates earlier that week, I have trial commitments, and the previous dates week on dates suggested by Mr. Meadow, I'm also not available during to existing trial commute. So it's placed on record, and it is found to have been aspects on which both the proctor and the other legal representatives had held themselves available. And those are relevant issues as reflected in the Investec matter to which we've referred in our heads of argument, where in a remarkably brief judgment from Judge Bin's ward, he raises the issue about other... I see Justice van der Merwe is smiling. But he raises the issue of the availability of other participants as being relevant.
Mr. Smuts, sorry to interrupt you. This is a apartheid matter. And you as an experienced counsel, you've also been in apartheid matters. The date that Ms. Dyantyi's counsel were not available was a date that they were proposing was just 1.5 months away from the proposed date of the 26th and the 27th of October. Now think about it, 2 weeks. In 2 weeks, they were not available, but they were available at the end of November. I'm just talking about dates. And they are steeped in this matter. This is a pro bono matter. Why was it unfair to just ignore the dates that were not available to Ms. Dyantyi and be fixed on a date of the 26th, 27th, and 6th, 7th, and 8th, which was the SWAT week? Why was it necessary for the university to say that 1.5 months was unacceptable, waiting for 1.5 months?
Well, for a host of reasons, the availability of the other parties to the process was a relevant consideration. The availability of the proctor and the prosecution on those dates was relevant. The fact that part of the unavailability, and that's the only aspect that...
Because why I'm asking you this is that on page 662, line 22, Mr. Sangoni, they're talking about dates here, and he says the proctor is available on the 25th, 26th, and the 27th, and then again on the 6th to the 8th of November, and then the 13th, 14th, and 15th of November, and then from 20th onwards in November.
Yes. Well, that may be in the proctor's availability. It doesn't. There isn't evidence that Mr. Powers. Well, he says at paragraph 10, line 10 on the next page, 663. No, Chair. I can say I'll deal with my November date, but I didn't say that I had no other dates. But there's no evidence that he was available.
He was concerned that he was going to be on a date when he was not available because he wanted to be available for his client. I think that's from his evidence. But what I'm trying to say is that, this is a apartheid matter. It's a comparison of 2 weeks and 1.5 months. And there's 700 pages I see from the heads of argument. People are referring to the matter as being long and they're steeped in this matter. I mean, why is it unfair or unacceptable to agree to the date that the dates that Ms. Dyantyi counsel was available?
Well, that
would be after the 29th of November.
Yes. Justice Alduka, there's an explanation on page 286, which is in volume 2. And at paragraph 61, the university's representative and deponent, Ms. Smales, says the following. The applicant requested that the hearing reconvene only in late November/early December, nearly 2 months after the conclusion of the proceedings on 11 October, as allegedly 2 of the 4 members of her legal team would not be available any time sooner. Part of her 2 counsel's alleged unavailability was due to their preference to embark upon attending a conference in New York rather than to attending the disciplinary hearing. The university disagreed with this request because it was simply unreasonable. The date suggested by the applicant would be almost 2 months after the last sitting and would be at a time when the university was preparing for its annual shutdown. The university was also mindful that the other student, Ms. McFall, and her attorney were, like the university, available to proceed with the matter at the end of October 2017, and then proceeds, and it's the point raised by Justice van der Merwe that I will deal with. No explanation was provided by the applicant as to why the other 2 members of her legal team could not represent her at an earlier date, and one which suited everyone else. This despite the fact that these other 2 members have also been involved in the matter from the very beginning. Now, Justice van der Merwe raises the aspect of the 2 counsel being unavailable, and should it be expected of an attorney to continue with the matter? Well, of course, the prosecution on behalf of the university was driven by members of the attorney's profession with a reasonable degree of success, and there's no reason to believe that an attorney could not have dealt with it and would not have dealt with it. And of course, importantly...
Of course an attorney could in principle have dealt with it. The question is whether it was fair and reasonable to expect the attorney who briefed 2 counsel for extended period of time now to just forego that.
Well, and our submission is that it was...
It's only just about a month later. I don't know about this 2 months. It was going to go on the 26th October or 29 November.
Yes, it's a month and a half, Justice.
More or less.
Yeah.
It's anyway postponed for half a month. So
But
it's a question of whether it should proceed on 26 October or 29 November.
there is, however, the reference in the passage which I cited, Justice Van der Merwe, that the university is then in the process of shutdown at the end of November.
But
and
why is that important? I mean, there would have to be a balancing of rights. This young girl, whether she's been making trouble or not, is entitled to procedural fairness.
Yes, indeed. May I refer to paragraph 82 of our heads of argument? And this is the position set out by Mr. Ndabe, the attorney, in the postponement application that was brought. He deposed to an affidavit. The footnote says that is in record volume 1, page 156, paragraph 8. This is what Mr. Ndabe said. Ms. Dyantyi cannot procure alternative legal representatives. She is represented pro bono by a team of 2 counsel and an attorney. And we know there was a candidate attorney as well, which is not entirely irrelevant, but certainly Mr. Ndabe was part of that team. This team, he says, the 2 counsel and he as an attorney, is familiar with the matter, has heard the evidence, and has spent extensive time and resources assisting Ms. Dyantyi to prepare her defense. And the court will have seen the various references in our heads of argument to passages in the record that reflect that Ms. Dyantyi withdraws because she's consulting with Mr. Ndabe, the attorney, and one or other of the counsel for purposes of preparing her evidence. There's no suggestion that Mr. Ndabe was not competent. There's no to run the defense. He says he's part of a team which is familiar with the matter, has heard the evidence, and has spent extensive time and resources assisting her to prepare her defense. The issue of the paternity leave is an ex post facto issue, which is not raised as a ground for postponement. And of course, on the day when the hearing is to resume, and there isn't an appearance either by Ms. Dyantyi or any member of her team, the court will recall that a telephone call is made to Mr. Ndabe, and he's found sitting in his office, and he says, "We're not coming." Well, with respect, the proctor was available, the prosecution was available, Mr. Powers and his client were available, and the response on behalf of Ms. Dyantyi is, "We're not coming." Well, to whom is that unfair? Is it not unfair to everyone other than Ms. Dyantyi? Because we know that her attorney, steeped in the matter, extensively involved in her preparation to present her evidence, was sitting in his office and was not coming. Was Mr. Ndabe ready and able to proceed? Well, we make the point at paragraph 89 at our heads of argument that in fact so steeped was Mr. Ndabe in the matter that he requested an extension in order to prepare written submissions on sanction. Well, could he have done that if he didn't know, if he wasn't capable of presenting the case on her behalf? The fact is, of course, he didn't. He requested an extension, he was asked for, he was granted an extension, and then he didn't prepare written submissions on sanction. But non-constat that he wasn't able to, that he wasn't in a position to conduct the defense, and plainly he had claimed to be in such a position. It was a strategic consideration that led to the boycott of the ongoing I'm sorry, I heard somebody, but I didn't hear the context. Question broke up.
Is it Judge Matadani?
It may just be.
You have a question?
Can I just ask this? The right to legal representation, even if the matter is parted, is that right absolute? Does that right entitle the appellant to just walk away from a disciplinary hearing, even if the code prescribes or the code requires or makes it a crime not to participate in a disciplinary hearing?
Well, Justice Matadani, it probably, accepting that it's an offence, but regrettably she's not here with an added charge against her for simply boycotting the proceedings. But that she had an opportunity to participate was there, is irrefutable. That she had a legal representative available who was steeped in the matter and was able to represent her is irrefutable. She chose not to attend the proceedings, and the court will recall that Acting Justice Genge was very critical of her in that other application because of her boycotting of the proceedings, and suggested in a sense that she was the author of her own misfortune. While I'm on that, of course, that urgent application that she brought was brought at very short notice, and the legal team that was employed to represent her did not take a great deal of time to come up to speed and to acquaint itself with the record. We've seen that the record that is before this court is substantially reduced because quite a lot of it, quite frankly, was unnecessary. But they were able to come up to speed and bring an application on her behalf in a very limited period of time. So even if alternative legal representation had been required, it was possible, and it happened in a very short period of time. May I, referring back to the issue of Mr. Ndabe and his role during the proceedings, refer the court to two references in the record which we submit are of significance. They're both in volume 2 at page 285. At paragraph 59, the university representative, Ms. Smales, who deposed to this affidavit, speaking about the process of the hearing, says this: following this, the applicant, together with her attorney, Mr. Ndabe, and the counsel, frequently requested and were indeed permitted to be absent from the proceedings, as the applicant on most occasions stated that she was consulting and preparing for her defense. Mr. Ndabe is inextricably linked with that preparation. And again, at page 303 in the same volume, at paragraph 137.2, Ms. Smale says this: in fact, Mr. Ndabe and Ms. Pillay, that was the candidate attorney, also excused themselves from the hearing on numerous occasions with the applicant on claims that they were preparing the applicant to give evidence in chief. It is significant that they did not appear to lead the applicant in tendering evidence. In broad answer then to the question raised by Justice Matadani, whether or not she was entitled to, and it's not in dispute that she was entitled to legal representation, our submission is she had available legal representation steeped in the matter, and chose, as a matter of strategy, not to return to the hearing, seeking to postpone the matter to a time after she had sat her examinations, which would have meant that the university no longer had jurisdiction over her when she ceased being a student, and quite frankly, we know that even at an early stage in the postponement application, Mr. Mabe was raising the prospect of the unfairness of the procedure, which may have given rise with respect to the observation by the proctor that she never had any intention of coming to give evidence. The extract that we rely on in the Investec Bank matter is cited at page...
Mats, before you just move on to the Investec, if I can just clear my thoughts on the matter.
Yes, Justice Hughes.
There seems to be a lot said about the attitude of the appellant and her counsel and or her attorneys and the candidates' attorneys. But we need to put it in context, because we need to look at what happened on the 11th of October in the discussion. And what is telling is that the proctor, even after being told, moved from the premise, and I specifically refer to page 676, moved from the premise that he had set the dates, be that as it may, that the appellant's team was not available, but he had set the dates with Mr. Power and with the university's representative. So my question is, what then was the appellant supposed to do? Because he says at line 6, Mr. Marlow, I think I must do the dates now. All right, 26, 27, 6, 7, and 8 November. Thank you. You can pack up. That's what he said. He doesn't even give them an opportunity. And on top of that, my other issue that I have is that even in the face of that, he doesn't even advance reasons why he's saying we will be proceeding on those dates, because one, I don't believe that you went to New York, or you could get X, Y, and Z to represent you, or you could do this, or you could do that. He doesn't. Even in the formal application, he doesn't. So without his explanation, all I have is that he, on his own, said, this is the dates, thank you, pack up.
Yes. To the extent that there is reliance on PAJA and the entitlement to reasons, of course, Section 5 of the Act entitles a party to request reasons, and we have no evidence that any such request was made. And if you don't ask, you may not receive. And we make that point. It is not that the applicant, that the appellant was not heard. There's extensive debate about availability, and he then comes to his decision. The appellant herself says that there were extensive discussions on and off the record, and it certainly came to a time when a decision was required to be made. The counsel were not available, it was not suggested, and couldn't have been, because we know that the attorney was still available, steeped in the matter as he says he was, au fait with the facts and the conduct of the matter. And so with respect, it may be so that on the record, the reasons are not there, but the argument that was presented are there. He was not asked for reasons in due course. And of course, by the time he came to write his final judgment, in which often one finds in court proceedings and in tribunal proceedings, if an interim ruling is made, it is explained in the final judgment rather than at the time to delay further the proceedings. Well, of course, by the time he came to deliver his final judgment and ruling, the appellant had withdrawn from the proceedings. And so, with respect, it may well have been a waste of time and energy to provide such reasons. May I take the court to the excerpt from the Investec Bank matter which we quoted, paragraph 107. And at paragraph 19, his lordship says, whether the unavailability of counsel previously engaged in a matter might afford a reasonable basis for a postponement. At the instance of the affected party will depend on the facts of the given case. Fairness and the interests of justice are the principal determining criteria in all contested applications for postponement. Appropriate regard must be had not only to the position of the applicant, but also to the legitimate interests of the other parties in the litigation and the needs of the effective administration of justice. Ordinarily, and certainly where there is sufficient time for another advocate to prepare, which we know there was, because the alternative team in far lesser time came up to speed and were able to bring the application before Acting Justice Henley in the High Court. Alternative counsel should be instructed when counsel of first choice is not available on the date allocated for the hearing of a matter. And herein lies the rub with respect. To avoid doing this is in effect a delaying tactic. So, should the court have... Justice
Let me ask you said something previously about that if it was postponed till after her exams, the university would have had no jurisdiction over her. Just explain that to me.
Well, she was a final year student. She completed her examinations. That's the end of her university career, if she passed, of course. And so, if she sits for her... So if she sits for her examinations, she leaves, and she doesn't arrive on those dates, well, what does the university do? She says, well, they could have taken her degree away. We've made the point that there's no provision for the removal of a degree. That such provision as there is for somebody who obtained the degree unlawfully or by false pretenses, got their twin sister to write the exam or whatever. But not under these circumstances. And there can be no doubt that if she had passed her examinations, refused to attend the proceedings, and the university had sought to withhold the degree, we would have been here in a different dispute. So, with respect, it was important for the university to complete its hearing within the allocated time period, also because there was another accused who was a university student who was entitled to complete the hearing within the university year and hours.
Well, smart. That is where the university had an issue. That's the reason why the university was post-haste wanting to finish it off before the 20th, because she was set to write on the 20th was her last paper. I think between the 8th and the 20th was going to be her last paper. And then Miss McCall was writing within that space of time of the 6th, 7th, and that period. So that was the reason the university was anxious to ensure all dealings should be done and dusted by the 20th. Because they knew that afterwards there was going to be, they won't have any hold over her for her to attend. And that's one of the reasons why Mr. Myler was persistent in saying, we're not going to entertain any further delays. I'd like to, but we can't.
Well, it seems, with respect to me, to be a perfectly sensible and logical hearing that you complete that which you can within the allocated time period, while it may have some effect. But of course, it was also so that Ms. McFall was entitled to a completion of the proceedings and the hearing. And this is not a matter about Ms. Dyantyi. In fact, with respect, we know from Ms. DeVos's submission, which we've quoted in our heads of argument, not our learned friend who's with us at the moment, but it's a wide-ranging family. That in fact, Ms. DeVos, who did appear in the matter, said this case is about rape culture, and so there is always, with respect, the lurking spectre of the ulterior motive, which is being driven through these proceedings, and the university, Ms. McFall, everybody involved was entitled to bring the matter to a conclusion before the university here ended. It was possible to do so because an attorney steeped in the matter, who was one of 4 of a legal team, was available, sitting in his office, not arriving. And we say that is in accordance with the threat foreshadowed in his affidavit in the postponement application, that the issue of fairness was likely to come to the fore in due course. Well, hey presto, it did. And we say with respect then that the question, dealing correctly as our learned friend submits, deals with the facts of this matter. The facts of this matter indicated that there was not prejudice, that there was available legal, qualified legal representation steeped in the matter, which could have presented matter as strategic but any further. Because on the days in question, the lure and call of New York was more important than the case of the applicant, the appellant, and with respect, that is simply not good enough.
Mr. Smuts, are you saying, after having read the transcript of the 11th of October, that the proctor applied his mind rationally to arrive at the decision to postpone this inquiry to a date when Ms. Dyantyi's counsel were not available? Give reasons why he did that. As the presiding officer, I mean, I don't want to use the word presiding officer, but was he not required to weigh carefully all this debate that was going on around him, and to weigh as to whether or not there was prejudice to any of the parties when he came up with these dates? Surely it's not in the interest of justice to just say, these are the dates, let's just pack up.
Well, if I'd been presiding, I wouldn't have just pack up. But that doesn't mean that it's contrary to the interests of justice to make such a decision, particularly in circumstances. Under these circumstances, no, because there was a qualified, experienced, steeped in the matter lawyer available as part of an unprecedentedly large defense team for a disciplinary inquiry, capable of moving on with the proceedings. It wasn't prejudicial.
Was it fair for him not to give reasons, and only to give reasons if he's asked?
Well, with respect, as I've made the submission earlier on, it often happens in proceedings where there's an interlocutory ruling, that the reasons for the ruling are presented at the end, in the final judgment or decision. By the time this final ruling and decision was handed down, the appellant and her team had decided to withdraw from the proceedings. There certainly is nothing unprocedural or unreasonable in furnishing reasons in due course. And as I've made the point, the reliance is on PAJA. PAJA expressly permits of a request for reasons. We have no evidence that there was any such request. There is a seizure upon the entitlement to reasons without complying with the prerequisite of requesting that.
I don't think there's a seizure. What is more, he gave reasons for dismissing the formal application.
I'm sorry, Justice Van frozen on my screen.
Sorry, can you hear me now? Doesn't look like it.
Yes, I can hear you, Judge Van der Merwe.
It looks like Mr. Smuts can't hear me.
Mr. Smuts, are you still on the platform? Mr. Smuts?
Frozen, as far as I can see.
He's frozen. I think maybe he must go in and come out again. Come back in.
Maybe this is an appropriate time for tea.
Yeah, let's take let's take 5 minutes. Sorry, 10 minutes. What is the time? 11:50. We'll resume at 12 o'clock, if that's convenient to everyone.
I'll just come back. Thank you.
Are you back? Did you miss anything, Mr. Smith? Have you missed anything?
I missed the entire question of Justice van der Merwe, but I'm looking forward with bated breath to hearing it.
Yes, we were about to, but let Judge van der Merwe put it to you again.
Thank you.
All of this has been put to you before, but I just want to try to put it to you coherently. You've been, I know, longer in this business than even I've been. And imagine how you're in the magistrate's office there. There's been a trial. Trial's been going on for several days, and the person is presented by two counsel, an attorney and a candidate attorney. There's 700 pages of evidence, many witnesses. Now the time comes for the accused to testify, to present his case. Now imagine the discussion in the court that the prosecutor will say, well, we want it on the 26th October, and the counsel says, no, but we're only available the 29th. If there's nothing untoward, if there's no shenanigans alleged, anything like that, I can't see how anybody would say, no, that's fine, we can ignore that they're not available. And they must get other people into, if you take a practical approach to it. So my question is, are you saying that in itself cause no prejudice, or you're relying on some stratagem or something?
Probably both, Justice van der Merwe. In the first instance, this isn't a magistrate's court proceeding, which regrettably I understand I'm happily not often in that forum, but seems to stretch on endlessly from year after year to the end.
Don't focus on that. The question is, everybody says it's a long marathon trial. Everybody is here. The question is it going on on the 26th October or 29 November? Where on the acceptance that genuinely on the 26th of October counsel are not available.
Well,
isn't it prejudicial to either get other counsel or to get the attorney? It's not like you're saying I'm going to be unavailable for 2 years.
But with respect, our submission is these circumstances are fundamentally different. This is an institution with defined operating time periods. The institution, by the time that counsel eventually were available, inexplicably because their staff wouldn't work over a weekend, they couldn't work over a weekend, which is the point that Justice Nichols raised. Inexplicably,
this is dangerous because it seems like the university wanted to prevent her from getting the degree before she was even convicted of it.
Well, if she was to be acquitted, it would also require the matter proceeding to an end, so that there could be no dispute. But it wasn't just her, with respect, Justice van der Merwe. She wasn't the only accused. There were other persons involved who were entitled to finality, and were available to bring the matter to finality. And then, of course, there is the allure of a conference in New York, which was not to be held against the university or against the other accused or her representative. That was one of the reasons of unavailability. I missed a wonderful International Bar Association conference, which I would have gone to, all expenses paid, in Boston, which I've never been to, but would have liked to have gone to, because I had a very unfortunate appeal set down in a matter in which I had previously appeared, and I was seized at the matter. So I went and did that.
Any further points, Mr. Smuts?
On that, not on that issue. On the issue of costs, with respect, and in a sense that rebounds onto the debate that I've just had in answer to Justice Philomela. There are previous costs orders, of which Justice Nichols is aware of at least one, in the matter of which went before Acting Justice Henry, where she found that the appellant had acted unreasonably in absenting herself, in dragging out the matter and the like. So there's a contextual record of this isn't simply trying to test a legal point, entitlement to representation. There's an entire context here. Her behavior, which is partially relevant to these proceedings, has previously been tested and found wanting. And with respect, Firewatch is not the last refuge of every scoundrel. It needs to be applied, and if there's a genuine test of rights and the like, certainly. Although why a university, which is not the state, it is a partially state-funded organization, should have to bear the costs of former students testing legal points is a matter for some debate. But our submission in this regard is that the approach adopted here is one in which the appellant and her legal representatives are indeed responsible for their own misfortune, and I can do no better than refer to the Constitutional Court's final paragraph in the Lawyers for Human Rights versus Ministry in the Presidency matter, where with reference to Firewatch and Helen Suzman Foundation, the court found a worthy cause or worthy motive cannot immunize a litigant from a judicially considered, discretionarily imposed adverse costs order. And that, with respect, is what stands in this matter. The High Court here concluded that the application was inappropriately pursued and that this warranted an adverse costs order against Lawyers for Human Rights, which wasn't even pursuing a matter in its own interests.
Mr. Smuts, the court gave her leave to come to this court, and there was a reasonable prospect in the mind of the judge that there was success on appeal. So, I mean, what are you trying to say? That she shouldn't have come here? She shouldn't have pursued her relief?
Well, with respect, in a sense, the relief that she seeks was manufactured by the Court of Acquire in raising the point of the same.
Well, but she was given leave. She got leave to come here. I mean, what was she supposed to do?
Consider her position and consider whether she was responsible for her own misfortune with respect.
Well,
and we have argued.
That's what the Court of Acquire thought. They said it was clearly a reasonable prospect of success in appeal, and it gave her leave.
Even if her counsel was unavailable without proper reasons. And so,
well, unless you can show that her pursuit of the relief was frivolous or vexatious.
No, our submission is that it was simply without merit, and that it is a heavy cross to bear for this institution. And we know that tertiary institutions are, and I would submit, learned friend asked the court to take judicial notice of the fact the court is entitled to take judicial notice of the fact that tertiary educational institutions are carrying a substantial financial burden, and this institution ought not to have to bear the burden of testing an interesting legal point which has arisen by virtue of the conduct of the appellant and her legal representatives. So we would submit that the appeal should be dismissed with costs, including the costs of 2 counsel. I see our learned friends want the costs of 3 counsel. The record was extensive, but not that extensive. The matter is interesting, but not that complicated. And we see, with respect, that 3rd counsel I don't know whether he's in New York, but he isn't with us today. So, and in fact, we are told that up to a point at least, the representation was pro bono. So I'll leave it with this court, but I don't believe that the costs order sought by the appellants is remotely practical or justified. Thank you, Justice Sullivan.
Thank you, Mr. Smuts. Are there any questions from my colleagues for Mr. Smuts? Yes, thank you. Thank you, Ms. De Vos. Anything in reply?
Yes, I only want to deal with a few issues raised. The first is the issue of the New York conference. The fact of the matter is that Mr. Power wasn't available for that during that week of the conference. One sees that in the discussion about dates, but more importantly, and just for the reference, it's page 481 of the Record of Appeal, Volume 3, paragraph 115, where the fact is mentioned that the conference in New York was not an obstacle. So the fact is that matter was not postponed to the week where the conference was in New York. So it wasn't even discussed. The court has accepted that they're going to the conference, and those dates were not discussed. When the dates were mentioned, Mr. Power says that he's not available on those particular dates. That is the one point I wanted to make. Your ladyship proceed.
Enlighten me, when was the conference?
The conference was in the 14th, I think, from the 14th of November. This you will see in a letter that is on page 431, where the date of the conference is mentioned in the letter to the other side, and it's the 14th of November. But the fact of the matter is Mr. Powers was not available on the 14th and 15th, and it is set out in paragraph 115. He also says so in the discussion. I can't find the reference right now, but he does say that. So the conference is not the issue. The matter was not postponed to the 14th and 15th, so it never arose whether they're supposed to leave the conference and continue with the trial. That wasn't the issue here. The issue was they weren't available on because they had previous matters that they had to deal with, and that's the issue, and that's the only question when one looks at the question of whether it was fair or not. So I wanted to deal with that. Then Mr. Smuts makes much of it that there was a qualified and able and capable attorney. Well, first of all, we have no idea how capable or able this attorney is. There's no evidence on record about his abilities or whether he's a good or a bad attorney, but that is not the point. If I choose for Mr. Smuts to defend me in a serious matter such as this, where my whole future is at stake, and he is the matter becomes part heard, then do I really want his attorney now suddenly to stand in? I've chosen him. He's the man that is steeped in the case. So on what basis now do I have to be forced to make use of an attorney, which is if I wanted the attorney to represent me, I would have asked the attorney in the first place to do so. If I had that kind of belief in his abilities, I would have asked him and not get two counsel to defend me. So I submitted that whether he was capable or not is irrelevant for purposes of the particular decision. There's also an issue made of an urgent application. There's a difference between an urgent application trying to stop a hearing and continuing with an intricate disciplinary hearing such as this one. So we submit that is also not an issue. My learned friend tried during the course of his argument to make out as if this was a stratagem. He wanted to finalize the exams and then only have the hearing. Now, first of all, factually, there is no basis for this argument. There's no facts on the papers that shows anything of the sort. It's under oath. Two counsel were not available. That's the end of that discussion. Secondly, the exams were on the 6th of, the last exam I think was the 6th or the 8th of November. The decision by the proctor on the 10th of November, was on the 10th of November, and then on the 17th the sanctions came out, and the court will find it on page 738, volume 5, where the sanction was is set out in the judgment application for leave to appeal. And importantly, paragraph 6 reads as follows: any examinations, practical or any other means of assessment that Mrs. Dyantyi may have written or done during the November 2017 examination period, which have not been finalized in terms of the Rhodes University institutional rules as at the date of this order, shall be regarded as post pro non scripto. Well, that's the end of that point that was raised. But I think I submit that one should keep in mind that none of this was put before the proctor. He wasn't told that we want to finalize it so that she doesn't qualify if she's found guilty. That nothing of the sort was put before him. So he could not have taken that into account in coming to his decision. We say that clearly he didn't weigh up the issues before him in making the decision. He just followed Mr. Milo's request and postponed the matter to that particular date. So as far as the reasoning for the urgent finalization of the matter in October is concerned, I think this subparagraph 6 takes care of that. The question of reasons, why didn't he give any reasons? Why didn't he say, well, I think that they're lying to me and that's why I'm not going to postpone it, or everybody's being prejudiced and they're being difficult? Nothing of the sort. And to say that the duty is on the appellant to ask for reasons is ridiculous, with all due respect. She brought an application for a postponement after the dates were given, after he did not give reasons. The application was heard on the 20th. He gave gave his judgment, if one can call it that, on the 24th. So he had time to think and consider. No reasons. He simply says, I've considered it, I'm not going to revisit my decision, end of the story. So he was given an opportunity to give reasons. He still didn't give any reasons. All the reasons raised for his decision was raised ex post facto by the university in these proceedings. So we still don't know why he decided that it doesn't matter that these people are not going to be there to represent them.
Mr. Smuts, are you still on the platform, Mr. Smuts?
I am, Justice Salduka. I just thought you might not want to look at me.
No problem. I think we're still getting used to this platform.
Then it was raised about the question of her boycotting the proceedings. Now, I'm asking myself, what would have happened if Ms. Dyantyi arrived there on the 26th of October to continue with the hearing? She would then have given her evidence without being led and without having the help of counsel. Would that in itself not have been a ground for review of this decision made by the proctor? It must be, because if you're entitled to legal representation and they're not there, and unless there's a good reason, you must give that person the opportunity to get the legal representation. So it's not a question of she boycotted the hearing. She didn't have legal representation, so it would be pointless for her to go there without a legal representation, and that is what happened on the 26th of October. It's not a question of boycotting, as said by Mr. Smuts. And actually those are the only issues that I wanted to specifically address. The only matter that is still needs to be discussed perhaps is the issue of costs. Don't know what enter. Okay. I'm still on the platform. Okay, there we go. Thank you. I've made the submissions in the heads of argument. We submit that we should succeed with our application and that costs should follow suit. And if we don't succeed with our application, then Ms. Dyantyi should not be melted in costs, because this is a constitutional matter. It is a constitutional question. It's about access to courts and legal representation. and on that basis the biowatch principle is applicable. Mr. Smuts' argument that her previous actions drew criticism from courts, etc., those facts are irrelevant. The court must look at this case and whether she had reason to approach this court with her application, and if it's a constitutional matter, there's no reason why she should be melted in costs. So I would ask that the matter...
the cost aspect, Mr. Foss, is it for 2 council or 3 council?
No, it's for 2 council, just.
Yes. Thank you. Is there anything further? Colleagues, if you want to have any questions for Mr. Foss? Is Judge Nichols there? Colleagues, are there any questions for Mr. Foss?
No, thank you.
No question.
Thank you, Mr. Smith. Thank you, Mr. Foss. Thank you very much for the heads of argument in this matter. We will take time to consider and judgment is reserved.
Thank you.
As the court pleases.
As the court pleases.
Colleagues, we will meet on the other platform at about in 10 minutes. Is that sufficient time for all of you?
Yes.
Thanks.
Yes, thank you so much.
Thank you.
you can, particularly on basic services that are needed, that you can challenge and say we need these services. But yeah, it's a process that needs to be engaged on. Okay. Any others? Okay. Yo.
So I want to know something. Which is the quickest way when you're finding out what is